Lord David Clendon.
Mr Speaker, yes, it's a pleasure on behalf of the Greens to continue the agreeable tone of this debate, which Mr Naylor referred to. This is a good bill. The Greens have supported it and will continue to do so. It does some useful and necessary and indeed some important things around the giving of evidence and other court processes, so we will continue to support it. The bill, of course, amends the 2006 Act, which 10 years ago in itself was quite new. It did some different and interesting things, and after 5 years it was deemed appropriate that should be reviewed to ensure it was doing the best it could be, which of course triggered the Law Commission review, which published a document in 2013, and much of the content of this bill of course does reflect the recommendations brought by the Law Commission. In a sense, it's odd. The Commission came back with a general statement that the 2006 Act was in pretty good shape, that it was quite a fit-for-purpose piece of legislation, but then went on to propose 33 amendments to it, which might be contrary statements in one view. But of course, many of those 33 recommendations were for so-called technical and minor amendments, which is not to say they are unimportant amendments, and the chair of the Justice Electoral Select Committee commented on the issues of consistency, which is critically important both within pieces of legislation and between pieces of legislation, that we get consistency of definition and the like. So while many of those the recommendations were deemed minor and technical, it's not to say they're unimportant, and it's good to see them being enacted within this new legislation. So some of the more substantial changes or additions it's made are, as has been said, around protecting and indeed enhancing the well-being of people, vulnerable people, who often through no wish of their own are obliged to be before the courts. Children, complainants in cases where there's alleged sexual violence or violence of other forms. These are people who deserve the best and safest environment we can give them, the most secure environment we can give them when they're obliged to enter the court. And there's changes in this bill go some way towards achieving that. I'll speak briefly just to a couple of those. One has been mentioned, that there's the legislation will now contain the presumption that a child giving evidence in a court as a witness will be expected to use so-called alternative means, a child being defined as a person under the age of 18. And we heard from Mr Sheeran his contribution, an example where a young person was put in a pretty horrific situation, being obliged to be in the same room as a person who that young person believed had done them serious and significant harm. The provisions of this bill will create the presumption where the child will not be put in that situation, but also allows for exceptions to that, where it's deemed appropriate by the judge that it's okay for that young person. You might have a confident 17-year-old who's entirely capable and willing to stand in a court and say their piece. So this bill doesn't block that possibility, but it does, as I say, put the onus is on that being the exception rather than the rule, and that's a good thing. We have various technical means of achieving that. There's no challenge about that, be it video or other forms of recording technology or simply screens. So it's timely that we do this. So the one other significant change in this bill is that it changes the circumstances around the court hearing evidence around a person's previous sexual history, particularly a complainant. Sadly, there have been too many instances over the year where particularly women in this situation have suffered very aggressive questioning, which frankly has been designed to shame them, to ruin their reputation, to present them as being promiscuous. This is a very ugly way to have our conduct happening in our courts, and this bill will go some way towards diffusing that. Any reference to a complainant's former sexual history will need to be notified in advance. its relevance will need to be demonstrated, that it is appropriate, that it ought to come to the court, and obviously that any complainant will then have the opportunity to develop some response to that. So it doesn't exclude that sort of line of questioning, but it certainly puts, shall we say, it creates a little bit of decency about it, perhaps, if that's the right word. Finally, sir, the point's been made too that in the situation where evidence is given on video, there is no as of right access to that video or that recording or that evidence by any party to the proceedings. A case needs to be made that the access to the video or the other recording is necessary and important. Obviously, it is important in the general flow of our justice system that all parties to a hearing should have access to all the information that's applicable to it. But there are ways of getting around that, and I think the taking away the as of right nature that anybody involved might have access to that, what may well be video or information that is a very personal nature, it does again require the approval of the judge to say yes, it is appropriate for that person or that party to have access to it, and then there are significant constraints about what can be done with that. It's about protecting privacy, it's about people's well-being, and I think it also avoids, it does however avoid the risk of any evidence or even the appearance of any evidence being suppressed. So with those few words, I think I will leave it to my colleague who will be speaking later to make further comments on behalf of the Greens, but for the moment we're happy to support this legislation.
Dennis.